Hi friends, today we're going to discuss about registration of mental health establishment under Mental Health Care Act of 2017. I'm Dr. Suresh Padatmat, Professor of Psychiatry, Head of Telemedicine Center, Head of Forensic Psychiatry Services, working at NIMANS, Bangalore. Before I start my presentation, I would like to have a disclaimer. This presentation is for academic purpose only, and this is not a substitute for professional legal opinion. If you want to have a legal opinion, please do contact an advocate. Conflict of interest? None. In this video, we are going to discuss about registration of mental health establishment under Section 65, that is both provisional and permanent registration. Mental Health Care Act of 2017 received assent from the President of India on 7th of April 2017. In the same legislation, it also mentions under Section 33, Central Mental Authority should be formed. Also, under Section 45, State Mental Health Authority should be formed. But at the same time, on 29th May 2018, approximately after 14 months after the assent of the President, this Mental Health Care Act was notified as it is in force. That means the Mental Health Care Act of 2017 came into force on 29th May 2018. Let's understand different timelines under the Mental Health Care Act. The three important rules are, first and the foremost, Mental Health Care Rules 2018 for rights of persons with mental illness under Section 121 was notified. The second one was Mental Health Care Rules for Central Mental Authority and Mental Health Review Board 2018, Section 121 under subsection 1 and 3 was notified. The third was Mental Health Care Rules 2018 for State Mental Authority was also notified under Section 121, subsection 1 and 4. Please do remember, your state may say, we have not formed the state rules, but the central government has already formed the State Mental Authority rules. Hence, they cannot deny that they have not formed. However, the state government has liberty to amend these state mental health rules after taking permission from the central government. Otherwise, the State Mental Authority rules is already available online and it is already gazetted under the Mental Health Care Act on 29th May 2018. Further, on 16th August 2019, there are two important things also occurred. That is, guidance document for assessment of mental capacity under Section 81, subsection 1 was also drafted and notified. And also, the list of drugs, which are essential drugs, have also been notified under Section 18, subsection 10, which had to be given free of cost from the public health establishment. Further, the latest notification is on 18th December 2020, Mental Health Care Regulation 2020, that is for Central Mental Authority, has been notified under the Section 122. And the other important thing you should know under the Section 66(3), it clearly says that the mental health establishment registration should start once the State Mental Authority is formed, or else Central Mental Authority is formed. But please do remember, the Mental Health Care Act also says that within the 9 months of the assent of this legislation by the President, they have to form CMHA and the SMHA. So, by December 2018, all Central Mental Authority is formed and also State Mental Authority is formed. If they are not formed, the old State Mental Authority, Central Mental Authority will be considered as they are the authorities. But however, now the Central Mental Authority is formed and many of the states have also formed State Mental Authority. If they have not formed the State Mental Authority, the old State Mental Authority will be considered and it is in force. And by December 2018, all mental health establishments should start registering, especially the provisional registration. Under Section 65(6), the Central Mental Authority and also the State Mental Authority within 18 months should draft and notify minimum standards for different categories of mental health establishment. That is, by December 2019, the minimum standard should be notified. But however, the central government notified the minimum standards under mental health regulations under the Mental Health Care Act on December 2020. Registration of mental health establishment. So there are two types of registration which I discussed. One is provisional registration under Section 65(3), and also permanent registration under 65(3). So this registration is both new, renewal of also old registration. So these are the registration which have been notified under the Mental Health Care Act of 2017. At the same time, section 66(3) clearly mentions every mental health establishment existing on the date of commencement of this act. That is, the commencement of act will be considered as 29th May 2018, shall within a period of 6 months from the date of constitution of the authority submit an application for its provisional registration to the authority, that is respective central and state authority. Please do remember, I will repeat, the within 6 months from the formation of the authority. But at the same time, the legislation also has mentioned that the state government and central government should form the authorities within 9 months of the assent of this legislation. Please do see there is the state mental health authority rules have also been notified by the central government on 29th May 2018. So no state government can say that we don't have state mental health rules. These rules will be considered as state rules. However, the state government has a liberty to amend this rule and get it vetted by the central government, or the permission should be taken from the central government under section 121. Moving to the which authority where the mental health establishment should be registered. See, there are two types of authority side. One is central mental authority, another one is the state mental authority. All mental health establishment who are under the control of central government will be registered under central mental authority. So what do we mean by the control? The control is in terms of finance and the administration. So invariably, whichever has the maximum amount of finance is given, the central government, if it is giving the maximum finance, then the central government will be registering under the central mental authority. If the finance is from the state government, it will go under the state mental authority. There are certain institutions where both state and central will be funding. Now, which is the maximum funding? If the central is funding, then it will come under CMHA. If it is a maximum funding is from the state mental authority, it will go under state mental authority. Here, the issue of finance and the administration plays an important role where to register. But now the state mental authority will register depending upon the territorial, and also whichever not under registered under CMHA will be registered under state mental authority. All private establishments and also the state government related will come under the state mental authority for registration. So do not have any kind of what we call it as the doubt with regard to this. But however, there have been doubts regarding union territories where, like for example, Chandigarh, the hospitals, the mental health establishment there, should it be registered under CMHA or SMHA? Let me be very clear. If it is a private, invariably it will go under state mental authority. Now the question is, if the government, who is funding maximum? If in the union territory, if it is funded by the central government, it will come under CMHA. If it is funded by the state government, it will go under the state mental authority. So please do not have any doubt with regard to this. Now coming to the provisional registration. How do we do provisional registration? First and the foremost, within 6 months of formation of the SMHA or the CMHA, the provisional registration should be done. So the Form B is required to be filled, and it can be submitted online, or else it can be posted, or else you can submit in person for provisional registration. Please do remember, within 6 months of formation of authority, and the authority should be formed within 9 months after the assent of this Mental Health Care Act. This is the Form B, how it looks. This Form B has been notified under the Mental Health Care Rules, that is CMHA and MHRB, that is Central Mental Authority and Mental Health Review Board. Under that, it has been clearly notified. Form B should be filled by the person who is in charge in charge of the establishment. Please do remember, under this legislation, the registration will be given to the establishment, not by the name of the person. For example, Mr. X can be in charge of 3 or 4 establishment, and each establishment will be named in a different name. So the registration will be for the establishment, not by a person. Hence, please do remember, the registration will be for the establishment. And within 10 days of submitting the application, the state government or the central government will issue the provisional registration. However, the certificate of provisional registration will look like this, and it has to be given to the authority, to the person who is running the establishment. And please do remember, this is valid for 12 months. And to give this registration, no inquiry is required. And once the provisional registration is given, within 45 days, this list of establishments which are registered under SMHA, that is State Mental Authority, or Central Mental Authority, need to be published online. And this is how the registration details should be available online, that is basically in digital format, so that the people, the person with mental illness and the family members know where is the nearest mental health establishment available, whether it is public or private, for their utilization or getting services from those mental health establishment. Further, before the expiry of 30 days, they need to apply for renewal. No, sir, they did not apply and they forgot. Yes, if it is expired, they need to pay extra fees, and that extra fees will be notified by the SMHA for the state establishment, and also for the Central Mental Authority. Central Mental Authority will going to decide. Coming to the permanent registration. See, once minimum norms are notified, within 6 months, they need to apply for permanent registration. That means all mental health establishment need to register for permanent registration. They cannot run on provisional registration. That is, within 6 months of minimum norms are notified. Now, Central Mental Health Regulations have notified the minimum norms. That means within 6 months, all Central Mental Health establishment need to go for permanent registration. At the same time, if the application has been submitted for permanent registration, the Central Mental Authority or the State Mental Authority need to either reject or approve within 45 days. If they approve, it is excellent. If they reject within 45 days, that means the mental health establishment will be given 6 months time to fulfill. That means they have to fulfill those minimum norms which have been notified by the CMHA or SMHA. By chance, if they do not communicate at all, that means your mental health establishment is deemed to be registered. This is the beauty of the legislation. That means if the CMHA or SMHA does not bother about your application, the law says that your establishment is registered. This is where the 18th December 2020, the minimum norms are notified by the Central Mental Health Authority. And under the CMHA Regulation 2020, the Form C is for permanent registration. And also same time, under the Mental Health Care Act of Section 68(1), any person can give a complaint to the Central Mental Authority telling that this mental health establishment do not fulfills the minimum norms. And the minimum norms also need to be available on the website under the Central Mental Authority, or the regulations are available in the public. Those regulations are available. So on that basis, any person who is taking treatment or any person who knows that this mental health establishment is not fulfilling the minimum norms, the complaint can be given to the CMHA. And at the same time, if the CMHA or SMHA refuses or does not give permission for the grant of permission for the renewal or cancels the permission, that means the MHE, that is mental health establishment owner, can appeal to the High Court within 30 days. If they do not appeal within 30 days, that means the High Court has the prerogative to accept after that or not, depending upon the reasons given by the owner of the mental health establishment. Further, you should know the penalty for not registering. Suppose if the mental health establishment has not registered and they are running this establishment without registration, then the first contravention, for the first time, the 5,000 to 50,000 rupees penalty will be given. Even further, if they don't register, the second contravention, the penalty will be 50,000 to 2 lakhs. And in the third, subsequently, if they continue to not register, that means 2 lakh to 5 lakh penalty can be given under this legislation. To conclude, my dear friends, all mental health establishment need to be registered. Either it may be private or public. Depending upon who is giving the finance and the administration power, it will be registered respectively under the Central Mental Health Authority or the State Mental Authority. All MHE should have been registered till date now, that is by provisional. Now, all mental health establishment should apply for permanent registration because Central Mental Health Regulations have been notified on 18th December 2020. Thank you very much for giving your valuable time you like this video, please do subscribe and share. Stay safe.